We can admit you, Zane, your business travel or something?
Yes.
Okay. All right, I'll call the meeting to order. This is the DuPage County Zoning Board of Appeals, November 20th, 2025 meeting. We have, I'll indicate that all of the members are present with the exception of Mr. Rahman, who wishes to be admitted remotely. We need to take a motion to admit him remotely. The reason for his well, he has a business conflict. So
We have a motion to admit.
motion by Mr. Moran, second by Mr. Schultz. Is there any discussion on the motion? All in favor of the motion signify by saying aye.
Aye.
Any opposed? Mr. Rahman will be admitted. We have no minutes to approve. We have one continued case. This is a continuation of the case first heard on October 30, 2025, which is a variation to allow video gaming cafe restaurant within 1,000 feet of an existing video gaming cafe restaurant video gaming terminal establishment. And Mr. Armstrong is now representing the petitioner, so I'll ask Mr. Armstrong to take over.
Thank you, Mr. Carthel. Nice to see everyone again. Brian Armstrong for the applicant. I'll just
You know
run
what,
with
let's have you be sworn in. I guess you guys can be sworn in again. You were first time, but everybody raise your hand.
Okay. Do you solemnly swear the testimony given tonight's cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Sorry.
That's right. I know there were some exhibits marked last time. I have tried to duplicate those and I've added some exhibits. So I'll just run through the exhibits. You have the packets. Exhibit 1 is a survey. Exhibit 2 is a copy of an invoice for a G1 gaming license dated May 12, 25. And at the bottom of that is a copy of a check to pay for that license check dated May 19, 25. Exhibit 3 is the fire department recommendation for approval. Exhibit 4 is the issued building permit dated 11/6/2023. Exhibit 5 is the certificate of occupancy dated March 20, 2025. Exhibit 6 is a color printout from the county's GIS website, and the purpose of this exhibit is to show the board that you see we have this little island of unincorporated area where the subject property is completely surrounded by incorporated village of Addison. So this is just a visual, so you get to see how it is, property is totally surrounded by incorporated village of Addison. Next is exhibit 7, which is an aerial photo of the properties in the center, showing some of the nearby businesses across the street and next door. Exhibit 8 is also an aerial, but from a slightly higher perspective, so it shows more of the surrounding area. Exhibit number 9 is our petition signatures that the applicants secured from neighbors and nearby businesses stating that they do not object to their proposed use. Exhibit 10 is a letter from the owner of Royal Liquor in the same strip mall stating that he does not object to the gaming cafe that the applicants are applying for. Exhibit 11 is a summary of costs incurred in trying to open the store. Exhibit 12 is a project narrative. I'll go through most of that. And exhibit 13 is just the applicant's authorization for me and my firm to act on their behalf tonight.
They're all admitted.
I will try to minimize how much I repeat what you heard for the first hearing. I know you don't want to hear it again, but some of it will be duplicative. As you know, these applicants currently rent the space at 19W 344 Lake Street in Addison, which is zoned B2. And of course, the gaming use is permitted use in B2. They applied for a gaming license back in 2023, as you know. And as you heard last time, expended quite a bit of money, and we figured it out, it's about $250,000 in getting to this point now. And then when they applied for the gaming permit and when they were, when they applied for the building permit and when they were issued the building permit, of course, this 1,000-foot restriction was not in place. That didn't occur until about June of 24. They were well into their project for that. It's done work on the build out and had spent a lot of money by that time. And I know Mr. Carl had some comments about estoppel. I know that goes, partially as part of an estoppel argument, but it also is to explain some of the hardship here that they've suffered. They propose to operate 6 machines at the location. They are experienced gaming cafe owners. They own other gaming cafes. Based on that experience, they know that they'll get about 3 to 4 guests per hour. Those guests will stay on average of 30 to 40 minutes. Of course, they do offer alcohol for sale. In their experience, very few of the guests actually consume alcohol. If they do, they might have 1 glass of wine, 1 beer. That's all they sell, no hard liquor, just beer and wine. And they, the owners, so the operators, limit customers to 4 drinks during their visit. So nobody can have more than 4 drinks when they're there. The location would be open from 9 a.m. to 1 a.m. on weekdays and until 2 a.m. on weekends. I think you're probably all familiar with Lake Street. So 2 lanes each direction plus a center turn lane, so a 5-lane road, very heavily traveled, very busy road. A lot of commercial businesses. With this particular location, just to the east is a tattoo shop and an auto repair shop. Across the street on the south side of Lake Street is 3 fast food restaurants and a Jiffy Lube and the American Tap Bar and Restaurant. And then to the west, there's a retail tile store and a massage facility. They completed their build-out work in March of 25. And then after that is when they learned about the 1,000-foot restriction that had been put in place. As I said, that restriction didn't exist when they started this process. I showed you the exhibit 6, which depicted how the property is totally surrounded by Village of Addison, incorporated Village of Addison. Village of Addison does not have 1,000-foot restriction. In fact, they don't have any restriction in their ordinance at all as far as distance between facilities. So in Addison, you see American Tap across the street has a facilities, has gaming. Millie's Pancake, just a couple doors down on Lake Street, also has gaming. There's a Lacey's Tavern a little bit farther down Lake Street on the north side of Lake Street. It also has gaming. The only gaming facility within 1,000 feet that is in unincorporated DuPage County is the Royal Liquor store that is in the same strip mall. Royal Liquor was not licensed for gaming when the applicant started this process. And in fact, they currently still do not have a gaming license from the state of Illinois. So they're not operating for gaming currently because they're not permitted by the state to do so yet. I think that, I think that means that the 1,000-foot restriction that the county enacted shouldn't apply to these applicants because that nearby facility is not operating for gaming because the state hasn't licensed them. Also, Royal Liquor is a completely different type of facility. It's a liquor store that sells packaged liquor and has gaming. The applicants here are going to have a gaming cafe where primary purpose and use will be the gaming. selling alcohol for consumption on site is ancillary to the use. Talk briefly about the 1,000 foot separation. You know, I did some research, tried to find information, and I was not able to locate any legislative history from the county board as to why the county board selected 1,000 feet. I know from my work doing zoning that that's a common barrier, common distance separation requirement that's imposed by a lot of municipalities. And typically it's imposed on like vice type uses, alcohol, tobacco, adult uses. And it originated, part of the origination of for it was to address potential concerns about negative secondary effects from these uses. Especially adult uses. That's where you see this reasoning most often is, the potential negative secondary effects from these uses. So we want to keep distance between them. That doesn't really apply here. That doesn't apply here for a couple of reasons. There's no school within 1,000 feet. There's no church within 1,000 feet. The Royal Liquor, as I said, is not operating. I think what Addison has done, I think, is really probably the best evidence of why this 1,000 feet does not apply here, and why those negative secondary effects are not a justification for it at this location here, because Addison has so many gaming facilities and all so close together, and they don't have any problem with it. I've never been made aware of any issues in Addison with their gaming facilities. You don't hear about people getting arrested at gaming facilities or coming out of gaming facilities about violence or fights at gaming facilities. I've never heard that. So the reason for the 1,000-foot separation really doesn't apply here. In addition to the fact that it's probably not even triggered since Royal Liquor is not operating as gaming. I will quickly go through, or try to quickly go through how the applicant meets the standards for variation. And some of this may be repetitive, so I apologize. First standard, that there are practical difficulties or particular hardships carrying out the strict letter of the zoning ordinance. As I said, the Royal Liquor was not in place when they applied and when they started, and before they expended all this money. They would not have spent all this money and time on this process had they known that 1,000-foot restriction would be applied to them. If they're not permitted to open, they will default on their lease. They will not be able to pay their lease. That lease will be defaulted. The facility will not open, and they will have lost all of that time and money. And I know how much money they spent is not necessarily a zoning consideration, but the hardship that results from losing that lease and is relevant to whether they should get a variation, because it is a real hardship. The use of variation would be in harmony with the general purpose and intent. It would not be injurious to the neighborhood. As I said, as you know, gaming facilities like this are permitted uses in B2 in this district. So that's a legislative determination by the county board that such a use is in harmony with the zoning code and is not injurious or detrimental to the neighborhood. Also, as I said, the area is already very heavily commercial with fast food restaurants, bars, Jiffy Lubes, auto repair, and auto service stations. So they're, having a couple of people come in per hour to the gaming is not going to result in any adverse consequence to the neighborhood. When they operate their gaming facilities, they do check IDs, of course, because they sell alcohol, so they have to be vigilant about checking IDs, which they do. They do not allow underage people to enter the gaming portion or the gaming facility. As I said, this is not going to generate a lot of traffic. It's not going to generate a lot of foot traffic. It's not going to generate a lot of car traffic with about 3 customers per hour on average. The next standard will not imply an adequate supply of light and air. They're not proposing to do any exterior. They have not done exterior modifications to the building, so it's not going to have any effect in that regard. Fourth standard will not diminish the value of the land in the building in the vicinity. Again, given the heavy traffic area and the uses already existing at this location, and that the county has already determined that this use is appropriate in this district, their use will not value the land, and granting the variation will not decrease the value of the land. Will not unduly increase traffic congestion in the public streets and highways for all the reasons I said already about the use and their level of use from customers. There are 16 parking spaces in this parking lot, which is, certainly more than adequate for an average of three to four customers per hour. It will not increase potential for flood damages to adjacent property, since they're not doing any modification to the outside of the building. They only modify the inside of the building. It will not incur additional public expense for fire protection. As I mentioned, one of the exhibits is the fire department, fire protection district's recommendation of approval. And then the last one, that it will not impair public health, safety, and welfare. Obviously, the county has determined that gaming is permissible, and that these types of facilities generally do not have negative effects on the public, which is why they allow them. Of course, the Village of Addison, even though this is not in the Village of Addison, it's surrounded by Addison, they have the same opinion, because they allow gaming facilities without any restriction of their own on how far apart they have to be. The facility, the other locations that are in Addison, as I said, also demonstrate that there's no injury to the public from these uses, and there wouldn't be an injury if the variation is granted. So I think for those reasons, the applicant does meet the standards for the variation, and we respectfully request that you recommend approval of the variation from the 1,000-foot distance separation.
Okay, thank you. Mr. Armstrong, on your exhibit 6, could you show us the location of the Royal Liquor facility?
Yeah, so there's a property line there that's about two-thirds of the lot is west of the property line, and 1/3 of the lot is east of the property line. Do you follow me there?
Yep.
Okay, so east of the property line is a tattoo shop. Okay, west of the property line, there is the applicant's facility, which is at the western edge of the building that's shown on that exhibit. Then the next unit in that building to the east is where the Royal Liquor is. And then to the east of Royal Liquor, there's a pawn shop. Is there anything else in there?
No, pawn shop.
Okay, so those are the 3 units in that building.
So the 1,000 feet is like right next door.
Yes.
I don't have any other questions. Anybody have any questions?
I have one.
I have one. I just,
Go right ahead.
the health department, commented that the facility will not meet health code chapter 18, I'll say this 303.5. And could you address that?
Let's see. I see where there's a comment from the health department, but I don't see what their actual rejection is.
Well, it doesn't say. It just says will not meet that particular section of the health code. Mr. Haas, do you have any information about that?
I did had
It's my understanding,
clearance from them.
Okay, wait. Sir?
Talk to me.
Paul Haas, DuPage County Building and Zoning. It's my understanding that because this is considered as a video gaming cafe, there's the presumption that there could be food being served here and being developed on the property. And that's what the objection is from the health department. But it's my understanding that this is only going to be liquor and video gaming.
So the health department is, in the event that there's foods to be served, they may have a health department issue?
Correct.
All right, we'll let them resolve that. All right, I think that's resolved.
Okay, yeah, and my client just advised me, he believes he has an email from the health department. I think saying they are okay with it. He had some follow-up discussion with them. I don't have that. I can, if I get that, I can submit that as an exhibit if you'd like.
Well, yeah, that would be helpful. I mean, it seems to me that if the what's before the board at this moment is the health department has a general objection that says certain section of the code. Follow-up information from the staff is that's not applicable because food won't be served. The testimony from in this case has not been that food would be served, just liquor.
Correct.
So it's all academic, but your email would be of benefit. All right, any other questions? All right, well, we can close the hearing, and it seems to me the record is complete, so we can consider this at our December 4 recommendation meeting, which is 5:30. There's quite a number of these cases, all of which are really, while they appear to be identical requests, they all have unique fact patterns, and so it's going to be a real marathon to keep them all straight and render our recommendations, but it's 5:30 on December 4th. Okay? Great,
right,
thank you
thank
very
you.
much. I'll indicate there's no old business, no new business, so we are ready to adjourn.